I'm Kevin Carnes. As your lead clerk and comptroller, I'm committed to ensuring you have helpful and easy to access service from the clerk's office. This how-to seminar is designed to assist you in navigating your court services and Lee County's official records. You can attend these sessions in person or view them online at leeclerk.org. I hope this convenient service enhances your customer experience with my office.
Hello, and welcome to your Lee County Clerk of the Circuit Court and Comptroller's Office how-to webinar on filing an injunction for protection. My name is Yesenia Williams. I am the Community Relations Manager for your Lee County Clerk of the Circuit Court and Comptroller's Office, and I'm delighted to go over this information with you today. A brief overview of our webinar. We'll go over some general injunction information, including some definitions, the different types of injunctions that you can file a case under, as well as the required forms and information that you need to gather to file an injunction for protection, the steps in the filing of an injunction for protection process, including what happens once that injunction is filed. We'll talk a little bit about Hope Cards, which is a new resource that is being offered by your clerk's offices, how you can electronically file an injunction for protection, and finally some available resources. So the Lee County Clerk's Courts Department is who facilitates the filing of an injunction for protection. We are located at 2075 Martin Luther King Jr. Boulevard, pictured here on the first and second floors of that building. To file an injunction for protection, you will come see us on the first floor of that building. We do have a satellite office located in Cape Coral at 1039 Southeast 9th Place on the second floor. You are able to file an injunction for protection in that office. And our contact number is 239-533-5000. Another service that your clerk's office offers is our Self-Help Center and Justice Navigators. Our Self-Help Center provides the public with legal resources, and this includes forms, internet access, and free legal consultations with Lee County Legal Aid, which we help schedule with Lee County Legal Aid. Our Self-Help Center is located in the Lee County Justice Center on the first floor. We also have a special role in that office called the Justice Navigators. Justice Navigators are there to assist self-represented litigants with services such as court form preparation, electronic filing, searching and accessing court records, legal aid appointments, again with the Lee County Legal Aid Society. You're able to obtain copies and print documents, and phone and Zoom access. I do want to mention that the Lee County Clerk's Office is a ministerial office, or in other words, a government office. So we can provide you with procedural guidance and information, but we cannot provide you with legal advice. We are not attorneys, so we would not be able to advise you legally when it comes to your court case. Some additional general information regarding injunctions. So injunctions are also known as restraining orders. You may have heard them referred to as a restraining order, but an injunction for protection is a court order against a particular person who has been physically violent with you, has placed you in fear of physical violence, or is stalking you. If a restraining order or injunction is granted, it will legally prevent someone from having contact with you, subsequently ordering that they stay away from your home, your car, place of employment, or any other places that the court finds necessary. This individual would also be forbidden from contacting you in person or by phone, email, social media, or any other electronic means. The filing of an injunction for protection is a confidential process. This means that the case is not considered a public record until law enforcement has effectively served the alleged abuser. And we'll go over what that looks like. Before filing a restraining order and to avoid delays and ensure proper service, certain information is required. Full name. So full name is a soft requirement, meaning we do need a name to open a case. However, we can file it with just the first name. This doesn't mean that the judiciary or the courts will accept it. It is up to them to ultimately decide if they're able to move forward with the case. So we do recommend that you gather the full name, even if just the first name is, you are able to file with just a first name. The address. So the address isn't required for filing, but it is required to serve the other individual with the injunction. Without an address, law enforcement is not able to serve that individual. This address can be work, home, or any place that this individual hangs out or that you know this individual can be found by law enforcement. Some additional information that's not required but recommended includes the date of birth, a vehicle description, a physical description, or any weapons, criminal history, and or drug or alcohol abuse history. It's just important that you include as much information as possible to help law enforcement find the individual to serve them. We do have all petitioners fill out this party information sheet, and this party information sheet is something that would include all of the information we just talked about. So again, just including as much information as possible. This is what the law enforcement will use to serve the individual with the injunction. So there are 6 different types of cases that victims of abuse can file a restraining order under. These types of cases are domestic violence, repeat violence, dating violence, sexual violence, stalking violence, and vulnerable adult cases. So we'll go over each one of these individually. All of the forms that are needed to file under each one of these cases are available on both our website and in our self-help center and customer service lobbies. So if you are wanting to obtain the forms on our website, if you visit us at leeclerk.org, under departments on the main page, you will see domestic violence and injunction for protection right on the left-hand side. Once you click on there, it'll have each one of the case types and the forms that go along with each one of those case types. So now we're going to go ahead and go over each one of the individual case types that you can file a restraining order under. Domestic violence is the first one. This includes any criminal offense that results in physical injury or death of one of the family or household members by another who is or was residing in the same home. Some examples of criminal offenses can include aggravated assault, battery or aggravated battery, sexual assault or battery, and stalking or aggravated stalking. The next case type that you can file a restraining order under is repeat violence. Repeat violence is 2 incidents of violence or stalking that were committed by the respondent, one of which must have been within 6 months of filing the petition. So if, for example, you filed a domestic violence petition 3 months ago and another incident has occurred, then you would file this time under repeat violence. Some examples include, again, assault or aggravated assault, battery, aggravated battery, sexual assault or battery, stalking or aggravated stalking, or kidnapping and false imprisonment. The third case type you can file a domestic violence injunction under, is dating violence. So dating violence is violence between individuals who have or have had a continuing and significant relationship of a romantic or intimate nature. The existence of such of a relationship will be based on certain factors. So some of the factors to base this existence of this relationship include a dating relationship that must have existed within the past 6 months. The nature of the relationship must have been characterized by the expectation of affection or sexual involvement between the parties. And finally, the frequency and type of interaction between the persons involved in the relationship must have included that the persons have been involved over time and on a continuous basis during the course of the relationship. So that means that it does not include violence in a casual acquaintanceship or between individuals who have only engaged in ordinary fraternization or in business or social context, excuse me. It must have been over time and on a continuous basis. The next case type that you can file under is sexual violence. So this includes a lewd or lascivious act as defined in Chapter 800, committed upon or in the presence of a person younger than 16 years of age, luring or enticing a child as described in Chapter 787, or sexual performance by a child as described in Chapter 827. While there is heavy emphasis on children, this case type can be filed with adults as well. Some other charges in any other forcible felony where a sexual act is committed or attempted, and then again, child or adult, regardless of whether criminal charges based on the incident were filed, reduced, or dismissed by the state attorney's office. So in other words, if this applies to you and you have gone to law enforcement and charges have been pressed or filed against this individual, or even if those charges were filed and then dismissed by the state attorney's office, you're still able to file an injunction under the sexual violence case type. The next case type is stalking violence. So this includes any one incident that has occurred between individuals, including harassment, which is any conduct where there is substantial emotional distress caused to a person that serves no legitimate purpose. A pattern of conduct composed of a series of acts over a period of time. A verbal or nonverbal threat or a combination of the two, including threats that were received by electronic communications or implied by a pattern of conduct which places the person in reasonable fear for their safety. And finally, cyberstalking, which means to communicate words, images, or language through the use of electronic communication that causes substantial emotional distress to that person and again serves no legitimate purpose. The final case type that an injunction for protection can be filed under is the vulnerable adult case type. This is a person 18 years of age or older whose ability to perform the normal activities of daily living or to provide for their own care or protection is impaired. This impairment may come from a disability, whether that is emotional, sensory, long-term physical, or developmental, brain damage, or infirmities of aging. And this is per Florida Statute 415.102, subsection 28. The exploitation may come in the form of knowingly obtaining, using, or depriving the vulnerable adult of their funds or property, a breach of a fiduciary duty to an elderly person or disabled adult, misusing or transferring without authorization money belonging to the vulnerable adult from their bank account, or failure to provide the necessities for the vulnerable adult's support or maintenance. There are required forms and information that you need to gather and file when filing an injunction for protection under any one of these case types. One of those forms is an injunction statutes for interview form, and I'll show you what that form looks like here in the next slide. In addition to that interview form, it's also imperative that the filer gathers specific dates of abuse or threats of abuse, specific locations where the abuse or threats occurred, and any previous or pending attempts to obtain an injunction for protection against the alleged abuser. So as I mentioned, we will ask that the petitioner file or complete and file an interview form for injunctions for protection. And this is where the petitioner will review the 6 different types of cases that an injunction can be filed under, and the petitioner will have to choose and initial which case type they are wanting to file under. We do, again, as I mentioned, have all of the forms available on both our website and in person in our self-help lobby and customer service counter for each one of these case types. These are called packets because there are a series of forms that are part of each one of the different case type packets. So as you'll see in the next few slides here, the forms themselves are labeled the same, but the information that is needed from the petitioner in each one of these packets varies. So while yes, there is a petition in the domestic violence packet and a petition in the repeat violence packet, those petitions are different, and the information requested or required is different. So these packets will consist of the petition, which will include all of the information that we just talked about that you need to include regarding the specific information on the incident, if you will. A cover sheet for family court cases, a designation of current mailing and email address, and this is so we can properly notify the parties of the petitioner of updates to the case. The party information sheet, which I went over earlier in the presentation, that'll have all of that specific information for the alleged abuser, for the law enforcement to serve them, and the petitioner's waiver or non-waiver of return hearing. The same forms are needed for a repeat violence case. Dating violence are also the same forms, as well as sexual violence. The stalking case is also the same: petition, cover sheet, designation, the party information sheet, and the waiver or non-waiver. The one that differs the most is the vulnerable adult packet. There is an additional form on there, which is the consent for the petitioner to file on behalf of the vulnerable adult. Again, all of these packets and forms are on our website. Petitioners are able to file electronically for an injunction for protection. There's two ways that you can do that. You can either use TurboCourt, which is a third-party service that not only you can electronically file the documents to the clerk's office, but it also allows you to prepare your forms using their services. So you're able to type in all of the information and it'll populate it onto the required forms. You're also able to file electronically using the Florida Courts e-filing portal. The e-filing portal does not prepare the forms for you. You would have to download the forms from our website or obtain them in person from our office and then fill them out by hand or by scanning them into the system, and then you would upload the forms into the e-filing portal. So those are two different ways that you can electronically file an injunction for protection. You are welcome to come visit us at our self-help center, and one of our justice navigators can also assist you with this process. So when it comes to the steps associated with filing an injunction for protection, so you know what forms are required and the different case types that you have to choose when filing an injunction. So once you've decided that and you've completed all of the forms, you will file those forms with our office, with the clerk's office. And you can do that in our downtown Fort Myers office or our Cape Coral office. The clerk's office will then file the petition and have it sent immediately to the judge that is assigned to your case. The courts will review that petition and make a decision within 24 business hours. And upon making that decision, they will contact the petitioner with that decision. There are 3 different types of decisions that the courts can make within those 24 business hours. Those decisions are granting your petition with a scheduled hearing, denying the petition outright with a scheduled hearing, or denying and dismissing your petition. If you are not contacted within 24 business hours of filing that petition with a decision, then you may contact the Domestic Violence Unit of the Administrative Office of the Courts at 533-2884 for an update on your case. The clerk's office accepts the petition and files it, and the courts ultimately are the ones who decide and make that decision within 24 business hours. The clerk's office is not the one that makes that decision. So I do want to make that distinction. So now we're going to go ahead and go over each one of those decisions. So if the courts within those first 24 hours granted your petition with a hearing, the sheriff's office will then receive that petition and they will serve the respondent with a copy of the petition for an injunction, the temporary injunction because it was granted, and a notice of hearing. A copy of that temporary injunction and notice of hearing is also emailed to the petitioner if an email address is provided. That hearing will be scheduled no more than 15 days from the date of the decision. Both parties must attend that hearing and testify under oath regarding the exact circumstances of the alleged incidents. The judge assigned to the case will then determine at that point if a permanent injunction or restraining order will be granted. If there is a permanent order granted, the petitioner will be provided with a copy of that order promptly after the hearing, and it is imperative that that order be kept on the petitioner at all times. If the initial petition is denied with a hearing, the sheriff's office will still be provided, with all of that to serve the respondent, and they will be served with a copy of the petition for injunction, an order setting a hearing without the issuance of a temporary injunction, and a notice of that hearing. The order setting a hearing without the issuance of the temporary injunction and the notice of hearing is also emailed to the petitioner if an email address is provided. And as with the granted decision, the hearing will be scheduled no more than 15 days from the date of the decision. Both parties must attend this hearing and testify under oath regarding the exact circumstances of the alleged incidents. And again, the judge assigned to the case will determine at that point if a permanent injunction order will be granted. If it is granted, again, the petitioner will be provided with a copy of this order right after the hearing. If the courts deny and dismiss the initial petition, that order denying the petition is issued when the judge initially denies that request. So once that order is signed by the judge's office, then it is issued to the petitioner at that time. The respondent will not receive this order. This is because if you recall at the beginning of the presentation, injunction cases are kept confidential until the respondent is served. Because the courts denied the petition, this means that the respondent is not being served, so that keeps the case confidential. Only the petitioner with valid identification will have access to any of the case documents that were filed within that case. If the case is dismissed at the actual hearing, then the courts will issue that dismissal at the court hearing upon the judge deciding on the case. The clerk's office is able to provide appropriate forms should there be a need for perhaps a modification, extension, or any other additional filings for an injunction for protection case. These forms are also available in our self-help center and customer service lobbies. There may be incidents where residents in Lee County are interested in filing against residents in another county or state. Petitioners will need to contact the county where the respondent resides to obtain certain information in order to move forward if that applies to you. So this information includes the law enforcement agency that serves summonses in that county, the cost associated with serving a summons in that county if applicable, as well as the acceptable payment methods and a mailing address for that agency. Once the petitioner has obtained this information, they must complete the same forms that they do when filing a petition, including this information, along with any service fees if it applies to them. Again, this is if a Lee County resident is trying to file a petition against somebody who lives in a different county. This brings us to Hope Cards, which I mentioned earlier in the presentation. So during the 2024 legislative sessions, the Florida legislature did pass Florida Senate Bill 86, which requires clerks of court to develop and implement a Hope Card program in Florida. In support of this legislation, a person who has been issued a final injunction for protection against domestic violence, stalking, repeat violence, sexual violence, dating violence, or abusive exploitation of an elderly person, so all of the different case types that we went over, may apply for a free digital or wallet-sized Hope Card with clerk of court information. Hope Cards make it easier for domestic violence victims to verify that they are recipients of a protective order. This is an example right here on the bottom left of the page of what a Hope Card looks like. So instead of having to carry the order, if there was a permanent order that was issued by the courts, instead of having to carry that 8.5 by 11 document, you can request a Hope Card that can be concealed and kept in your wallet. It is provided upon request and only with final orders of protection, not temporary ones. The clerk's office will issue this Hope Card within 3 days of requesting it. The Hope Card is valid for 2 years or until the expiration of the injunction, whichever comes sooner. It can be reissued after 2 years if the injunction is still valid. If you have any questions regarding Hope Cards or are interested in requesting a Hope Card because you do have a final order of protection, please email us at hopecard@leeclerk.org. Some clerk contacts and resources available to you. Again, you've heard me talk a lot about our self-help center, the Honorable Linda Doggett Self-Help Center, located in the Lee County Justice Center on the first floor. Our Justice Navigators are also located in the Self-Help Center, and you may reach them by emailing justicenavigator@leeclerk.org. Lee County Legal Aid Society is a great resource if you are looking for legal advice or legal assistance. They can be reached at 334-6118 or leecountylegalaid.org. The Lee County Clerk of Courts Department can also be contacted at 533-5000 or courts@leeclerk.org. Our website is also a great resource with lots of comprehensive information regarding this process, including this presentation and PDF version of this presentation. You may access that at leeclerk.org/DV. And finally, the Administrative Office of the Courts website also has some great information, including a Florida Courts Injunction brochure. Abuse Counseling and Treatment Centers, or ACT, is also a great resource offered by our community. ACT is a private, not-for-profit agency that is committed to serving victims of domestic violence, sexual assault, and human trafficking. They offer free, safe, and confidential services for adult survivors 18 and up of domestic and sexual violence and their children in Lee, Hendry, and Glades counties. Some of the services that ACT offers include a 24/7 helpline that can be reached at 939-3112, an emergency shelter, counseling and support, sexual assault support and forensic exams, and legal advocacy. Learn more about ACT and the many services that they offer by visiting their website at www.actabuse.com. That concludes our presentation today. I encourage you to connect with us online, whether that be through one of our social media channels or by subscribing to our newsletter to be informed of future events and updates on our services. You can do that by visiting our website at leeclerk.org/subscribe. You may also reach me directly at ywilliams@leeclerk.org or 533-2763. Thank you.